Good afternoon, everyone, and thank you for joining us today for part one of a three-part series, Are You Ready for a Liability Claim? Before we begin, just a couple of quick housekeeping items. Your phones have been muted. However, if you have questions, feel free to enter them in the chat box on the left side of your screen, and we'll take those questions as we go. A copy of today's presentation has been emailed to you, and we will be asking several polling questions throughout today. And we'd like everyone to respond to those, but especially if you are requesting CPE credits, you are required to answer all polling questions within a timely fashion. Before we begin, especially I would like to thank the folks at Wright Specialty Insurance for sponsoring this three-part series to make it available to all of the ABEC member institutions at no cost. Thank you very much, Wright. I'd like to introduce our two speakers. Paula, I think it's Pavlidis, and she's probably going to correct me when she comes on the line here. Paula is an attorney with Congdon, Flaherty, and O'Callaghan. And, of course, you all know Bob Bambino, Executive Vice President at Wright Specialty Insurance. Bob, let's go ahead and get started.
Okay, thank you very much, Bruce, and thank you, everyone, for having us today. Just a little bit of background information on Paula. Paula is a trial lawyer who has taken over 30 cases to verdict. She doesn't want me to reveal her win-loss ratio, but it's very good. Prior to being a trial lawyer, Paula was an assistant state attorney general. She has a law degree from St. John's University, and she has over 20 years of practice in the field of law. Okay, good. We have the next slide up. Hold on one second. Let me see if we're better here. This is probably better. We chose the first webinar to cover premises and operations losses. Premises and operations losses are essentially accidents that give rise to claims that usually give rise to litigation at some point thereafter. And these are incidents that occur on your premises and as a result of your operations as a college or university. So some of these things could occur off your premises if you have sports activities, athletics, off-premises or off-site courses, or if you have some type of college-related travel for students or others. We recognize that litigation can be complicated. It can also be very confusing. It also has an emotional overlay. When you get a summons to complaint, even if you're expecting it, it's nerve-wracking. The allegations that the plaintiff's attorneys will make accuse you of negligence. They accuse you of doing something wrong. They're worded harshly at times. There's a money demand in most cases. So we recognize the fact that there is always an emotional overlay on a case, even one where there is belief that you will prevail and win. Although the insurance company takes control of the litigation process, smart CFOs will stay involved and keep abreast of the process. It's usually the insurance company's money that's involved, and I'll talk about that in a minute, but it's your college's reputation, which we take very seriously, and it's something that I know you take seriously as well. A poor outcome in litigation can affect your premiums going forward. It could also affect your insurability at some level. The insurance policy that handles these losses is known as the Commercial General Liability Policy. This policy covers colleges and universities for their routine and everyday operations, and it also covers you for liability, as I mentioned before, that arise out of off your premises. The general liability policy usually does not come with a deductible or a retention. The policy is experience rated, meaning that most insurance companies will base future premiums on what their loss experience is on your behalf in the past. Like an auto policy where, you have an accident, you're at fault, you get your renewal, there's an increase in your personal auto policy premium, you call your broker, and the broker says, well, you did have a couple of losses over the course of the last year. The same thing works here, and the same kind of theory applies. The general liability policy is the policy in play for this discussion. For the third one, which will deal with assault claims and security-related risk, the policy that we'll talk about next week is really the educator's legal liability policy, which is a whole other thing. So let me take it to the next page here. And this kind of outlines really what the litigation process is like. Paul is going to go through it in a little more detail. All I will say is that there might be some differences from state to state, so you might hear other terms, but it's essentially the same thing. What I'd like you to keep in mind is that the expenses that you might occur, so for example, the insurance company will appoint counsel, they'll appoint defense counsel on your behalf. They are responsible for any other expenses that come out of this. If you are asked to produce records or documentation and there's an expense involved, you should certainly talk to your broker about whether or not you'll be reimbursed for that. So, Paula, why don't you kind of take this for a while?
Sure. Typically, the first stage in the litigation would be the school's receival of a summons and complaint, which will outline all of the allegations against the school and may also include any of your staff could be named in the complaint as well. At that stage, you need to turn over that summons and complaint as quickly as you can to your insurance company because there are always deadlines as to when an answer must be provided to that complaint. At that point, once the insurance company receives it, they will send it over to counsel, and we will review it. If it is something that looks very blatantly like it's an improper party, that the school has been named improperly, or it's an improper jurisdiction that is being brought in, or something looks just on its face improper, regardless of, fault or where liability will lie later, we will oftentimes contact you, your contact person at the school, and come up together with an affidavit which would be prepared by the attorney, sent to the school district to be executed by the appropriate person. And sometimes the attorneys will, rather than answer, which we know we have as number 2, which is typically the case, but in certain cases we might do what we call a pre-answer motion to dismiss the complaint. So that might be your first contact with the attorney to just, for us to gather some information. We would need to determine whether we answer or move to dismiss the complaint at that point. If we don't move to dismiss the complaint, depending on the jurisdiction you're in, sometimes the answer needs to be verified by the appropriate person at the school. So you might receive a copy, once again, from us now of the complaint and our answer that we've prepared. And at that point, you'll be asked to sign a verification page and return it to us so once again we can timely serve the answer on the school's behalf. Likely what happens very quickly after receipt of the summons and complaint, and even in some cases where you have notice of a potential accident or a notice of an accident that might potentially come into litigation, the insurance company will send over an investigator to the school to obtain various documents from the school, records regarding students involved, if that's what's involved, to photograph areas of the accident, to interview any staff that might have any knowledge with respect to it, possibly ask the school to intervene if they want to interview any students that might have witnessed or been involved in it at all. But that's really going to be your contact with the insurance company's assigned investigators. And I think some of the slides, do we want to just go more briefly over this one? Yeah. Then basically the next thing that happens after that is when the defense attorney serves the answer, we're serving discovery demands on the plaintiff to seek some more information about the case. And likewise, at that same time, they will be serving our office with further demands, with any issues or information, documents, et cetera, that they're looking for from the school. So at that point, we would obviously, again, contact you if it hasn't been provided to us already in the investigation we've received. The next really big portion of it would be the depositions, which occur typically after most of the written discovery has been exchanged between the parties. And at that point, through what we've received, we typically just determine which witness from the school would be most knowledgeable about the issues or the allegations, and you would come and be prepared by one of the attorneys, and we're going to get more into that, I think. After that, sometimes issues arise at the depositions when the plaintiff testifies or when the defendant testifies that would lead one party to seek further information. So we call those the post-discovery demands. Your you would be involved in that also, in providing or assisting us with that. Certain times, site inspections will be required when the plaintiff's counsel or defense counsel wants to come onto your school premises, look at a piece of equipment, look at an area. Sometimes experts are involved in that as well. And the final stage, obviously, is the trial, where we would once again meet with you and go over, even in much greater detail than the depositions, what would be expected of you at trial. So those are just generally the stages.
And Paula, typically in state court, how long might this entire process take?
Depending, it's really in New York, county to county, but it could easily take 3 years or more. And you rarely see a case coming from summons and complaint to trial in under 2 years. It's rare.
Okay. The next slide here just deals with some of the general liability theories or theories of liability that plaintiffs' attorneys will put together when they make claims involving premises and operations losses. And these are the allegations that would typically be made against the college, or as Paula said, in some cases, individual people in the college who are named in the litigation. And on the right-hand side, we'll go over what some of the typical defenses are. So if you are served with the summons and complaint and you are involved in the process, the left-hand column is what's typically going to be alleged. And then on the right-hand side, these are the defenses that the insurance company, investigators, and defense counsel will be thinking about. So why don't you just kind of run through them a little bit?
Sure. So what we typically see with liability theories against the school districts are the colleges are failure to provide adequate supervision. That could be in the classroom, in the dorm. That could be during extracurricular activities, sports, or theater programs. Any time the school goes on a trip or has any type of excursion. Obviously, we see a lot of defective and dangerous equipment cases. Those come in different kinds of instructional classes where there might be equipment like automotive classes, et cetera, or any kind of dangerous equipment that would be used at anywhere physically on the campus premises. Inadequate facilities, we see those claims quite a lot, that they are conducting an activity in an area that has not been properly set up for that activity. Inadequate security comes in cases involving typically dorms or rooms within dorms that are locked or unlocked or under general surveillance, which is inadequate or allegedly inadequate. And typically out of those security cases are where we see the assault claims. Other cases that we see really are with untrained or poorly trained staff. They will typically, in their complaint, allege failure to hire competent personnel. Another issue that we have seen quite often is failure to instruct, and that could be in any of your college courses. That's sort of on the newer end here, where we've been a bit successful in defending a lot of the claims that occur. We defend them by saying that there is no notice of this defective or dangerous condition, or no notice that would allow a claim for negligent supervision to be successful. So plaintiffs' counsels are tweaking it and now just saying, not only do we think you're not supervising properly, we don't think you're instructing the students in what they're supposed to be doing in whichever class they are properly, and that's added on as a claim of negligence. So in order to defend those claims, we're often arguing that the person involved, the injured person, the plaintiff, has comparative negligence, meaning that they have contributed in some way to the accident, or assumption of the risk. And in assumption of the risk cases, this goes state to state, and it's continually developing. In New York State, they've just recently made assumption of the risk can only be a bar, which a total bar, meaning as opposed to comparative negligence where you can find some faults on the plaintiff and some faults on the defendant. In assumption of the risk cases in New York, it's a total bar. It's a 100% win for the defendant if you are able to defend a case on assumption of the risk. But New York has very recently said that can only be in cases involving sporting activities. We used to be able to allege assumption of the risk if you're at a college event and people start horseplaying, et cetera. We used to say, well, you've assumed the risk by, knowingly engaging in an activity that can cause harm. So different jurisdictions are having different rulings on this. Right now, as it stands in New York, on a horseplay case, we're no longer able to use the defense of assumption of the risk. Another defense we use typically in excursions or sporting events is the waiver and release that's often required to be signed prior to a student's participation in an athletic event or on an athletic team. And statute of limitations is the time limits you're allowed in order to pursue a claim, which are different. In your colleges, some of the students will be under the age of majority and some will be above the age of majority. So the statute of limitations differs with respect to minors and people who have reached the age of majority, and we often use that as a defense in our claims.
So, Paul, think about like a typical slip and fall case where you have a visitor, they're coming to the campus, let's say, to attend a theater production or a sporting event. It's the winter. There was some snow on the ground. It was cleaned up. The person's walking in. They trip. They fall. Let's say they sustain a very serious injury. What would they typically allege against a college or university? And then how might you apply comparative negligence to something like that?
Okay. In that kind of a case, they would typically argue that the school district failed to provide a safe, the colleges failed to provide a safe way to ingress onto and off of the premises, that they failed to maintain their parking lot, sidewalk, etc. in a satisfactory condition, that they will go on to say, although you were able to remove some snow and ice, your actual actions of removing the snow and ice actually contributed further to the accident because you did it in a negligent fashion and made the condition even worse. So typically when you get these summons of complaint, you're right that there is an emotional factor, but we have to remember that a lot of the allegations are what we consider boilerplate. They have to throw in everything, and so that they're not precluded later for failing to allege something. They need to allege sort of the whole kitchen sink and then work through all of that discovery phase of the litigation to see what really, really, truly was the cause of the accident. So that's typically what they would allege: failure to maintain a safe, adequate premises, and then they go further specifically, and they'll say specifically for this plaintiff on X date and X time when she was attending X event.
And how would you apply the comparative negligence defense to that?
So during the discovery phase and the deposition phase, you just ask fact-specific questions with respect to what did you see, could you see where you were walking, were you looking where you were walking, what type of clothing were you wearing, was any of your clothing obstructing your view, was there any person or persons in front of you that was obstructing your view, what type of footwear were you walking, with what speed were you walking, where had you driven onto the premises of the campus, had you passed over as you were driving the area where your accident happened. You're just trying to get as much information as you can, putting that person either in the area where the accident happened before the accident, or having them walk across the area for a long enough time that they should have realized and walked another way, walked more slowly, got back in their car and parked somewhere else. You're just trying to put any amount of comparative on that person that you can.
All right. So 2 questions. Number 1, is it worth shoveling?
Absolutely.
Okay.
Yes. And oftentimes the colleges will even have, outside contractors come in to do that. So this is always a way to pass liability from the school right onto what we call a third party. And that would be by the defense counsel actually commencing a third party action wherein the college now becomes the plaintiff, the third party plaintiff, suing the contractor. And sometimes the independent contractor, snow removal, already has an agreement with the school that they will, indemnify the school or hold the school harmless for any accidents occurring as a result of their alleged negligence in shoveling.
Okay. And then my second question is one up on the screen. Is it worth getting waiver and release forms? We get questions from brokers and from colleges and universities periodically where they'll say to us, is it worth getting a waiver and release? Would you mind looking at our form? Do you have a sample form? So is it like, let's say you have, you're running some type of a program and you're going to ask, let's say you're running a program like under continuing education and you're going to ask the people that are coming in to sign a waiver and release form, or you're going to offer some type of a rec program and you're going to ask the people who come in, maybe minors, the sign a waiver and release form before they get in. So is it worth it?
I do think it's worth it. It is not always an absolute bar from recovery. It's certainly more worth it for someone who has reached the age of majority, because a minor cannot sign away their rights or right to sue. But if you have a parent and a student that have both signed the waiver, sometimes the waiver is good enough to preclude the parent's lawsuit for lost wages if they've lost time taking care of the minor, or loss of income from taking the minor to various doctor appointments, or for the minor's medical bills. It would all depend on the wording in the release. You typically can't sign away negligence, but it's definitely a piece of the puzzle, definitely a portion of comparative negligence, and even assumption of the risk in some jurisdictions. It becomes an argument that you assume the risk, you knew, you signed a waiver and release, and that's what it goes to the defense.
And what we do is when we get a chance to look at them or make recommendations, we always say, make sure that you clearly articulate in the release what the activity is. And if it's a situation where there's a third-party vendor coming on campus, let's say, that's going to run some type of program, or if students or other people are going off-site to, let's say, they're going to an outfitter, maybe they're going out to do some type of kayaking, maybe they're doing canoeing or whatever, whitewater rafting, or they're going hiking, if the third-party vendor or the locale that you're going to has a website where they're advertising what the activity is, we always tell them, you know what, put a link in there, let everybody know what they're going, where they're going, what they're going to be involved in, because sometimes there are people that just simply shouldn't go, and if they have the opportunity to see what the activity's like, they might say, you know what, not for me. Okay, Bruce?
Let's go ahead and ask a poll. Let me pull this up real quick. Our first poll of the day. Who handles litigation at your institution? Is it the business office? Do you have on-staff legal counsel? Do you hire an attorney as needed? Maybe your risk management office? Or maybe you have no assigned person or you're not really sure. So just let us know. While we're getting these answers coming in, Bob, I have a question for you. A general assumption is that Title IX sexual assault claims aren't as prevalent at Christian colleges versus a secular institution. Is that a reasonable assumption?
You know what? I saw that posted on there, and quite honestly, one part of me would believe yes, but what I'd like to do for that is I'd like to go back and look at our loss experience and then try to see if I can make a determination as to if we've got a number of sexual assault claims on colleges and universities in higher ed, how many of those were at Christian colleges and how many were not. So if I could, I think Bill Powell asked this question. Bruce, maybe I can get back to you within a day or two, and perhaps we can put the information out to everybody who participated.
Yes, that would be perfect. And it looks like 72% of our folks hire an attorney as needed for litigation on an institution. About a fifth of the group says the business office handles it, and just a handful have the risk management office handle it. So how do you feel about that, the two of you?
I think I completely get the idea about working with an outside attorney. I think in many cases, or in some cases, general counsel or the university's general counsel will be involved in the litigation. I think that's a very good thing. We would like, I think as we go through the discussion, you realize that there are many points where either the defense counsel appointed on behalf of the university or the insurance company's own people need someone that they can contact that can get them information where they can talk about whether or not a deposition date works. They can find out whether or not there are records that have ever been held or kept. So whether it's outside counsel that has to make the phone call, or if we have contact or defense counsel has somebody in the college who they can contact, it kind of works the same way.
Okay, great. Let's continue on.
Okie doke. Okay. All right, so let's take a look here. Hold on a second. All right, so I think this is really the kind of like the first phase. Paula had gone over that a little bit. A point from our perspective, and then we'll go into a little more detail. The general liability insurance policy, like every other policy that's in play, has a section that's called duties after an accident or loss. On the auto policy, it's like protect your car, get it appraised, allow us to look at it. On the property policy that covers damage to a building, it's, protect the building, board it up, cover the roof, and give us the opportunity to go in there and take a look at it. With the general liability policy, two things to keep in mind. In both of these, if they're not complied with, could affect coverage later on. And it rarely happens. I don't even know if it ever happened with us. But first of all, if you have notice of a claim, or you have a reasonable suspicion or belief that it could give rise to a claim. So if somebody shows up, let's say at central administration and says, "Listen, my mother got hurt on Friday. I'm going to sue you guys. I'll own this building in a year. I'll see you in court." You need to notify the insurance company about that. Certainly, and notify your broker actually. If you are served with a notice from an attorney that says, "Hey, I represent this person, we are considering a claim against the university, please forward this to your insurance company," you need to get that information to your broker or to the carrier as quickly as possible. If you are served with the summons complaint or a summons, that also needs to get over to the carrier as quickly as possible, and Paula will explain to you in a little more detail why that's so important.
I think I started to say it before, the summons and complaint needs to get to the insurance company, and the insurance company, they know they need to get it to defense counsel as soon as possible, because there are very short time limits. In most jurisdictions, it's 20 to 30 days to provide an answer to that summons and complaint, or stipulate to agree with the other counsel that you're going to extend the time to answer. And, answering it isn't just putting in random answers. When we receive that summons and complaint, we need to look into what we know already of your college, or contact you to get some information in order to properly answer it. Like I said, you're going to be verifying the answer, whoever the point person is at your school, and so all of it has to be a truthful, sworn to, verification that everything we have responded to is true. So sometimes it might be an issue as to where exactly did this incident, let's give a trip and fall as something, where did it happen? Was it on school premises, off school premises? Or sometimes we answer, at this time, we don't have enough knowledge and information to provide an answer. So typically, there's not too much that's actually admitted by the defense counsel in the answer, unless it's a very obvious allegation. And the summons and complaint will break down the allegations by paragraph. They will have one paragraph that you owned the premises. The second paragraph will say you maintained the premises. The third paragraph will say you operated the premises, etc. So we need to respond individually to each of those, and we need time to do that and obtain the appropriate answers. So it's very important to have it come over. If you do not answer a summons and complaint or receive a stipulation to have your time extended, they could a court could eventually come back and say, well, we deem everything in the summons and complaint to be true because we never received a timely answer, and then you go to what we call an inquest hearing, which is basically we're going to take plaintiff's word for it on all these allegations. Now let's see how much these damages are worth, which you never want to be in that position. So just as quickly as you can get it, it's very important.
And even with a small college or university, you want somebody up front who is responsible for sending them, scanning and emailing them over to the broker, keeping a record of them. Also, Paula, talk a little bit about how summons and complaints are properly served. So if somebody comes by and just throws the summons and complaint in, let's say, the college president's office, is that going to be good enough?
No. First of all, in most jurisdictions, not only does the summons and complaint have to be served, but the complaint actually has to be filed with the appropriate court also. There are, as we said before, statute of limitations, and they vary with respect to what the allegations are in the complaint, but the court and service has to be completed within the statute of limitations. It depends on the jurisdiction. Certain jurisdictions certainly require personal service, so they will have a process server come and serve whoever your point person is at your college with it. They'll come back with an affidavit that I served someone who was approximately 50 years old, X height, X weight, whatever skin color, and they will then annex that to what they typically file with the court to prove service. And so it's not always good enough just to, drop off. So in some jurisdictions that might be good enough, and also, like I said before, if you have a teacher or one of your staff members individually named, service on the school is typically in most jurisdictions not good enough for to be covering service on that individual as well. They need to be individually served. And it totally depends on which state you're in as to how service is to be handled.
So what happens if someone comes in with a summons or complaint and you say, I don't want it? I'm not taking it.
They could, what? Let's hope that if you have to have a point person who this is their job. So if someone comes into the central offices at the college and says, I have a summons and complaint to be served, hopefully the person at the front desk can go back to this person who should be your point person, and that person should be a little familiar with what typically is done in your jurisdiction with respect to a summons and complaint, what it looks like, et cetera. Because if service gets rejected, again, depending on your jurisdiction, they can use another method of service like a mailing, and if they can prove via a process server that you refuse to accept, in some jurisdictions the mailing would then be enough. It just depends on where you are.
And does service have to be on like an officer of the college?
Yes.
Interesting. Okay.
Yes.
So if they just walk, let's say they're trying to get into like the central office, there's a security system in place, they're not being buzzed in. Let's say a buildings and grounds or a person walks by, they have a blue shirt that has the name of the college on there, and the service, the person doing the service says, here you go.
Typically, the process server is typically identifying and will ask the person, what is your name?
Okay.
And they can't simply just serve someone on the buildings and grounds staff. It has to be someone who's actually designated to receive service on behalf of the school in order for it to be proper service.
Okay, thank you. Let's go to the next slide.
Okay, so the next portion of the puzzle would be when the insurance company sends their investigators over, and typically it's a investigation company that is familiar with what they're doing. So they've received a letter typically from the insurance company saying, please, this is who I want you to statementize, this is what I want photographs of, this is the information I want you to come back with. And the insurance company's investigators will, once again, contact the point person at the campus and typically set up an in-person day when they're going to come, interview, photograph, possibly if we're dealing with equipment issues or something that is heavily involved in the allegations or something that is alleged to be defective, not working, and that's the cause of this injury. Sometimes they will ask the school to preserve it, not only with the investigator's photographs, but actually to move the piece of equipment out of use if that's possible. They're going to come and ask sometimes if students are involved, if it is an assault on the campus between two students. Sometimes we want both students' records, their attendance records, their disciplinary records, if they have any history with the school. They would want any accident reports that were prepared in the regular course of the business of the school. They would want any records from any medical personnel from the school that attended to them. They would typically ask you for surveillance camera video footage. That's why it's so important to get notice of the claim or the potential claim to the insurance company, because we know that surveillance cameras typically tape over themselves after X amount of days. So if you have notice, as Bob was saying before, someone comes in, or even if something happens at one of your football events or something, and there are people from the college there to see it, and you're thinking, this is a significant enough injury or incident that I think it might end up in litigation, you should right away try and preserve any surveillance camera footage right away, even if you're there as an employee of the college. If you see something and you have your phone on you, I would say take a picture of it. Anything that we can preserve evidence as soon as possible. If it is a student involved, and sometimes if a student gets involved, the parent starts communicating with the school regarding the accident, we would ask that you provide to the investigator any of the communications between the parent and the school district. And then obviously, if it happens at an event or it's something other than a one-on-one assault that nobody sees, we want to know who the witnesses are and for witnesses to be statementized as soon as practicable after the incident occurs so that their memory is the best. Sometimes police get involved if it is an assault, so any communication that the school has with the police should be preserved, even to the point where you would say, the dean of whatever department at the college had contact with police officer X on X day and had a telephone conversation wherein we discussed the allegations. Just any kind of phone log, if that could be kept, is always useful just in preserving people's memories, if for nothing else. Basically, one issue that I would say is very important with respect to these investigators, you have to make sure that you know exactly who they are before you speak with them, because oftentimes the plaintiff's counsel will also send investigators or somebody to go to the school to photograph or speak with witnesses. So just be very certain, and don't worry about being rude if you have to say, I'm sorry, I have to check who you are with my general counsel or with the counsel that's been appointed or your outside counsel from that poll, whoever is handling your litigation for you.
Right. The way it should work is that the investigator may contact your broker first, and, from that point on, the broker may do the introduction. Most insurance companies will use, as Paula said, they'll use outside investigative firms, or some of them use their own people. So certainly you have a right to ask for identification, photograph the identification, or take a picture of it. Paula's right, plaintiffs' attorneys will send out their investigators, and every now and then, not that often, they get a lot more information than they needed. They get to speak to people that sometimes provide information that doesn't help, or maybe it's not accurate. So you always need to verify, and we get calls periodically where clients will say, I'm from this particular institution, this individual is on the other line, they want to come in here and they want to get records. Should we allow this person to come in? If you're not sure, don't let it do. Don't let them on. Call your broker. Call if you have if your college attorney's involved, let them get involved. But that's very, very important. So a couple of questions that come up from our clients. The insurance company does an investigation. Does the attorney for the claimant or for the attorney for the plaintiff, are they entitled to the information, for this information as well?
No, not right off the bat. They have to provide us, as I was saying, with appropriate discovery demands, and at that point, the defense counsel would determine what, if any, information they get. In many jurisdictions, information that is generated solely in anticipation of litigation is deemed privileged and confidential and would not be turned over. For example, in the case of taking witness statements, if you had taken a statement from a staff member that saw an assault or saw a trip and fall or saw or witnessed any portion of the incident or the aftermath when the person was being cared for, those would typically not be turned over to the other side. They're deemed privileged and confidential. Depending on what's asked for by the other side, if it's overly broad or privileged in some way because the students' records who are not involved in this claim, or if it's an assault on your campus and plaintiff's counsel says, I want the student records of the other student involved, and that person is not a named party, the defense counsel for your school will not voluntarily turn that over, typically not without a court order, because the students have privacy rights under the Buckley Amendment, and they're federal, so they go across all states. So not everything gets turned over. And I would go one step further. Once you have a witness give a statement regarding the incident to the insurance company's investigators, I would say that it would be good practice to not provide that witness with a copy of their own statement even. Let that come over to the defense counsel because it is deemed privileged and confidential. However, if at a later time, when we get to the deposition stage, that witness is called in to testify and that witness reviews that statement in preparation for his testimony, that actually releases the privilege, and that statement now has to be turned over, where it was deemed privileged and confidential until he reviewed it in preparation for the deposition.
Paul, say you have a case where you have an athletic team, they're involved in a game, there's an injury on the other side, there's an allegation that it was done deliberately or that the college was negligent in letting their player play, they weren't trained properly, they weren't explained the rules. Let's say that the coach that was involved in that game that occurred maybe a year or two before is no longer in the employ of the college. Or let's say that the buildings and grounds superintendent who was in charge of snow removal on that particular day is no longer in your employ. What's the college's obligation?
Well, if that person is named in the lawsuit, typically the policies would cover that person as long as the actions that they were doing at the time of the incident were within the scope of their employment. If this kind of goes, again, on a case-by-case basis, if the person is still on friendly terms with the college and will willingly provide a statement to the insurance company investigators, that's, of course, a great benefit to the attorney, who can at any time call them as what we deem a non-party witness. But, of course, it's always helpful to defense counsel to know what is in that statement, what are they going to say with respect to the happening of that accident before I call them in. Because when we take non-party witness deposition testimony, we have to notify the other side so that both attorneys are present and both attorneys would have an opportunity to question that person.
But if it's, let's say it's somebody who left on poor terms, or let's say it's somebody that the college has no contact with, they have no idea where they are, they're not required?
Are they not required to to help the
Right.
defense? No. Once they are no longer an employee, they typically are not.
Okay. Okay. This,
Can I say one more thing?
Go
I'm
right
sorry.
ahead.
When someone does leave the employ and they're considered to be a pertinent party or someone with knowledge, the college does have the burden, when asked during the discovery phase, to provide the last known address of the person who has now left the employ.
okay. So this fourth stage here, discovery, demands, and responses, this is when for the purposes of this discussion, this is when the plaintiff's attorney makes a demand and asks for records, photographs, information, cameras, emails, other electronic records. They want the opportunity to maybe look at something. How does this work? And what would the role of, let's say, the chief financial officer be in this case?
They would have to facilitate getting any of the discovery over to defense counsel. So defense counsel will receive the demand from plaintiff's counsel, go through it, determine what they think is legally discoverable at this stage, rather than admissible, but legally discoverable, and they will seek that information directly from the point person, if it is the CFO at the school. And a lot of the information we already hope to have from that initial investigation, but oftentimes once they have their client come in and speak with them more specifically with respect to what happened, they get a little more specific in the demands. So instead of just saying, I want maintenance and repair records for the past 3 years on your vehicle that was involved in a motor vehicle accident, they might say, I also want the driving record on with respect to this driver, et cetera. So some things that may not have been obtained by the investigators originally.
Say you have, let's say it's a case where there was a summer camp, it was a soccer camp, there were kids from the community who come and play, one of them is injured while on the field, they have a fracture, they bring a lawsuit against the college. What might the plaintiff's attorney ask for in discovery for a case like that?
And the student is playing on one of our sponsored
Yeah,
events? Okay,
yeah.
our camp.
Yep.
At that point, they would likely ask for a list or at least a number of campers who were there and a list of who was supervising and what role they had. Oftentimes, they're trying to show you didn't have enough supervision for those students. They want to oftentimes know if any of those coaches, counselors, whatever you want to call them, were certified, what experience they had, and sometimes they can only get that type of detailed information through the deposition, but they're going to want to know, do they have coaching certificates, who was there, do you have any accident reports, are there photographs of the area that depict the condition. They always want to know if you have any statements taken by their client who might have said something right after to the coach. They want to know names of witnesses, and that's where it gets a little tricky because you can't always release the students' names. They want to know what kind of accident records they have with respect to the past several years of camp? How many other accidents have you had on that field or occurring during that activity? And that's generally what they're asking for.
Now, what about, let's say a college has a procedure where if a camper's injured or a student is injured, a visitor, and they get taken to the infirmary and they're, let's say in this example, the child has serious injury, the nurse or the PA who's there interviews them, talks to them, takes some information, maybe calls 911, maybe gets them transported to an emergency care center, and that person in the infirmary writes a record. Let's say it's called an incident report.
Mm-hmm.
Is that incident report something that the plaintiffs can get their hand on?
Definitely.
Okay.
Yes.
Any advice for those souls out there whose job it is to fill them out?
Yes. It's very important to just state exactly what was stated to you with respect, and on your report, state specifically who said it. So student reports fell on the field. If the student comes in and says, I fell while running on your track today in a giant hole near the 100-yard line, I would just place student states fell in hole at 100-yard line. I would leave out the descriptive factors with respect to what the allegations are. Once you put student states or coach states or counselor states, that can come in at the time of trial as an admission. If you simply say student fell and you're not indicating where you got the information from, oftentimes that would not be deemed admissible. It's just deemed what we consider hearsay at the time of trial. And as accurately as you can, reflect the information as to when the accident occurred and also when the report was generated, which may not be simultaneous. And indicate on it who was supervising specifically, if you can have names, instead of just saying coach supervising in case there's co-coaches, assistant coaches, et cetera, and lists of any witnesses. And, of course, keep the contact information for exactly what time you contacted the parents, what time the student came into the infirmary to show that you had prompt treatment.
And one thing that we'll do, if we get an opportunity to look at an incident report from one of our clients, if the report has information on it like what was the cause of the accident, what can we do to prevent it going forward, what was done as a result of the accident, we typically ask that to be taken off. That could be possibly another internal process within the university, but for the incident report, not a good thing to put that on there. Couple of questions here. What happens if you don't have the equipment? Let's say it was a goal in a soccer camp or during a soccer game, and there's an allegation that there was something wrong with the goal, and the goal was thrown out. It was just for routine reasons. What happens in that situation? And also, if records are gone, like for example, let's say they ask for information about what happened in camp on that particular day. The incident occurred 2 years prior. The counselor who kept the record is gone. The record's not material. Do you have to recreate it?
You definitely do not have to recreate any documents. You only keep documents that you have typically prepared in the ordinary course of business, and then depending state to state will tell you for how long you need to retain those documents. If they are destroyed for any reason or gone, you absolutely do not recreate it. The defense counsel will simply respond to the discovery demand by saying that the college is no longer in possession or is not in possession of the demanded item. You definitely do not have to recreate it. With respect to a piece of equipment like a soccer goal, as you're saying, being gone, that again becomes very fact specific. You have to give information as to when it was destroyed or thrown out or whatever, and we have to show typically that you didn't have notice of the claim prior, because if you had notice of a claim involving that soccer goal and then subsequently destroyed or allowed it to be released or for whatever reason gone off premises and out of your control, you get what you call a spoliation issue. And spoliation means that they can give a negative inference to a jury at the time of trial that the defendant purposefully got rid of the information, so you can assume anything negligent against the college with respect to whatever the allegation is with the piece of equipment. So you never want a spoliation issue. That's why I said if there's something that you have even notice of being a potential litigation, you should try and notify your insurance company right away. And one of the things those investigators will do will be at least come over and photograph that soccer goal. So even if it's gone, at least they can work off that. And once litigation is in suit over that soccer goal, you have to do everything in your power to find a place to store it for that time, at least until plaintiff's counsel has had an opportunity to have an expert engineer or whatever type of inspection they want of the piece of equipment.
All right, so I think everybody's kind of aware what a deposition is. It's an opportunity for each side, and if there are multiple parties to the litigation, everyone gets an opportunity to question witnesses and parties to the litigation. It's under oath, so there's always the issue of perjury if somebody's lying. Paula, maybe you could talk briefly about like who has to go and that kind of thing. But what I'd like you to talk about is like how do you conduct yourself? Just so you guys, I was deposed a few times in my life and kicked under the table more than a few times, which was probably a very scholarly way of telling me to shut up or don't talk so much. So maybe you could talk about like what witnesses should and should not do and what you're allowed to do.
Okay.
So the plaintiff's attorney serves a notice for deposition. Defense counsel gets it. They get in touch with the person at the college who's in charge or managing the litigation. What do they ask for?
Okay, so sometimes the plaintiff's counsel will specifically request a specific person and sometimes not. So depending on that, the defendant's attorney will determine who would be the appropriate witness. Prior to the deposition, you would meet with the defense counsel, and we just go over what I call like the general rules of a deposition, which is to simply answer the question asked, don't go any further. The example I always give them is, if you get asked the question, do you know who the President of the United States is? The answer is yes. Let them ask you, who is the President of the United States? The answer is not, yes, Obama, because already, like I show you, you're giving too much information. So you simply answer the question asked. If you do not have any knowledge of the answer, or you don't understand the question by any means, you advise the other attorney right away, I don't understand your question, I want you to repeat it for me, ask it to me in a different way until I understand it, but you don't take any guesses at any answers. You have to be 100% certain on it. If you don't know, the answer is I don't know. If you don't remember, the answer is I don't remember. The best case scenario for a defense attorney typically is to get yes, no, I don't know, or I don't remember. If you don't remember 15 questions in a row, you don't have to be worried the defense counsel is going to think I'm the worst dean a college has ever seen. It's not. It's what your best recollection is. And during that deposition preparation, we're going to be reminding you of the important portions that we would like you to remember, and we're getting that information from your witness statement, from other statements. You only answer truthfully. By all means, I don't mean to say, answer anything other than the truth, but you just don't take any guesses. Because even when you're trying to guess at an answer in effort to help the counsel, it's not helpful if the guess is wrong, and especially in cases, which most cases have, where you're going to have more than one person come give deposition testimony from the school. So to use a silly example, if someone said at the time of the snow and fall, slip and fall on snow and ice, it was snowing, and the other one says, no, it had stopped snowing, you have conflicting testimony, and that's very difficult to deal with at the time of trial. So you typically will go over the general rules, keep your answers short, sweet, truthful, and move on.
If the attorney doesn't ask for a specific person, so they ask for somebody with knowledge and information, is it better to bring somebody like the CFO in? Or let's say it was the snow and ice case, is it better to bring the person in who's responsible for grounds?
Definitely the person with more knowledge, and in that scenario you just gave me, the person would be the grounds person. Because once a witness comes in and does give testimony, and if they really have no knowledge of anything, the plaintiff's counsel is entitled to another witness. Okay. And the best case scenario for a defense attorney is to only have one witness deposed in each case. It doesn't happen often, but that's our best case scenario, so we have no conflicting testimony. So we always want to provide someone with actual knowledge.
So let's say in this snow and ice fall down case, the vice president in charge of maintenance of facilities, they come and testify. They're deposed by plaintiff's counsel. Let's say that the landscaping company that was responsible for snow cleanup, they're in the case also as a defendant. they get to depose the person also.
Yes.
Okay, and then on the other side, the defense counsel for the university and also defense counsel for the landscaping company, they get an opportunity to depose the plaintiff.
Correct. And the
Okay.
plaintiff's deposition will, in almost 100% of the cases, take place before the depositions of the defendant, and thereafter you go in the order of the caption. So whoever is listed on that summons the complaint first, that's the first witness to be deposed.
Okay, interesting. All right. So you do the deposition, and let's say that the attorney finds out that there was a third-party contractor who was involved.
Mm-hmm.
Or let's say that the attorney finds out that the soccer goal was repaired 6 months before the accident by an outside company that the college retained for that service. The attorney can then come back again and say, look, there's this additional information I need?
Correct. And then the attorney can make an impleader motion and actually implead into the case this new party. And when that new party comes in, that new party, depending on your jurisdiction, has the opportunity to redepose the plaintiff, redepose the college, if they deem the transcripts of testimony that they will have an opportunity to review beforehand aren't satisfactory to them.
Okay. So in terms of the questions, I think you answered the first one. If you don't know, the answer is I don't know.
Right.
Okay. And what happens if there aren't any employees left in the employ of the university who actually had any direct knowledge or witnessed the event?
Then typically you're going to, that's when you would probably produce a CFO to come in and state that there are no persons who are employed at this time by the college with knowledge. And sometimes, in addition to the deposition testimony, if someone did give deposition testimony to that effect, the court might also, in conferences following the depositions, request that the attorney for the school, the college, provide a further affidavit from someone in personnel showing that
Okay.
X, Y, and Z is no longer employed.
Okay. Bruce?
Let's go ahead and ask another poll for our audience. I'll pull this one up as well. Hold on. Our next question, how good are your retention policies and procedures? Do you have solid, proven policies? Do you think they're good, but they really haven't had a chance to be tested? Maybe you know they need a little work. Maybe you know they need a lot of work, or you don't have any. Or maybe you're not sure at all. Let us know. It looks like this one, the response is pretty much all over the place, but most folks, the majority, think that their policies and procedures are good, but they really haven't had a chance to be tested. We're going to ask another question related to this. Who manages your document retention on your campus? Is it the business office? Is it maybe the IT department? Your risk manager, your on-staff attorney? Or no one is doing that, or you're not sure who's doing that? Let us know. Looks like in 100% of the cases for our attendees, the business office manages document retention. Bob, how do you feel about that?
Well, I think that's a good idea. I think the IT department, typically has some role in terms of like where the documents get stored, how they're kept, how you can go into archive files and get the information back. Sometimes the IT department actually does take the lead, but in this case not, which is probably for the better. IT might have some recommendations that come about from their part of this, but I agree. I think it's the business office. And certainly if you have questions about things like how long do we maintain employee information, health information maybe, accident information, not a bad thing to either ask HR, people in HR, or maybe ask your own attorney for it. So good. I would have been upset if we found out that the risk manager was retaining all the information.
All right, let's continue on.
Okay. Paula, go ahead.
Okay. So another, this doesn't happen in every case, but in most cases, the plaintiff's counsel will want to come themselves onto your facility into your dorm, into the athletic facility, into your parking lot, wherever the accident may occur, to have their own personal site inspection. Certainly, your defense counsel, before the stage of trial, should absolutely do an in-person inspection of the area. I deem it like malpractice for you to not go there prior to at least trying the case. Oftentimes, the plaintiff's counsel will bring with them an engineer to, examine the lighting in the area, or take measurements of the steps in the area, or look at the grade of your parking lot, or measure your gymnasium or athletic facilities or your weight room and see how closely the different pieces of equipment are situated to each other. And then that expert engineer, expert in whatever the case may be, will then prepare a report for plaintiff's counsel. So typically, if plaintiff's going to have an expert inspect the area, defendant's counsel will likewise have an expert inspect the area, typically not at the same time. So whoever your point person is at the school would have to facilitate them coming onto the campus to view the area, and certainly accompany the person. Do not have any discussion other than about the weather on the day of the inspection with that person. We're not there to provide them with information. Typically, I would say absolutely your in-house counsel or the counsel that is handling the litigation process for you must be there when plaintiff's counsel is inspecting. They want to make sure nothing is altered. They want to make sure no employees of the college are speaking with them out of turn, et cetera. So you just don't provide any information. You just make access to the area available for them and allow them to take their measurements, do their lighting tests, do their gradation tests on the roadway, or et cetera.
So let's say you have a dormitory accident where somebody falls on the stairway in a dormitory. The plaintiff's attorney who comes on site and brings along, let's say, an engineer or an expert, they're only allowed to look at what are they allowed to look at? Could they say, well, you know what, it's a 5-story dorm, there's a stairway, there's 2 stairwells up and down, they fell on the stairwell between the 2nd and 3rd floor, we'd like to see the entire stairwell from the roof down. Could they do that, or are they limited to just the area of the accident?
Typically, that the courts will hold that what is discoverable is different than what's admissible at the time of trial. And discovery at this stage is much more broad. So I would say, yes, allow them to measure whatever they want, and then let the trial judge leave it to the jury's not going to hear anything about the 3rd and the 4th floor. They're only going to hear about the measurement of the riser at the area where this accident occurred. But typically, you have to allow them access.
Okay. And now what happens, so let's say that you have defense counsel there, maybe college counsel, someone from the CFO's office, and then the vice president in charge of facilities. If the engineer for the plaintiff says, hey, listen, how long was this crack here for? How long did you have this handrail up? Do they have an obligation to answer those questions?
They don't, but because your counsel's there, I would again say that is on a fact-specific basis, depending on what your case is about. And before the person gives the answer, the attorney can always pull that buildings or maintenance person to the side and say, do you even know the answer to this question? This is not an opportunity for the campus employees to be deposed, certainly.
Oh, okay.
So you can just say, you can save that for the deposition counselor, and they might require a further deposition if the inspection has taken place after the first time someone's been produced by the school.
And I think we kind of know the answer to the second question here, but let's say it's a security issue where an intruder got into a dormitory the plaintiff alleges that there was no security there. They just walked through the entranceway. There was nobody at the desk. And when it came to the swipe card system, it wasn't really working very well. What happens if the security in that dorm was, let's say, changed or upgraded in a period of time? What happens then? Could they still come and look?
They can still come and look, and typically they would already have that information through the written discovery phase before we allowed them on campus. We would say, as a response to a discovery demand, the school is no longer in possession of that system, or that system hasn't been upgraded since, et cetera. So at that point, the plaintiff's counsel leaves it to their own determination as to whether they would even want to come see something different, because a subsequent repair in the state of New York, I can answer for, is certainly not admissible at the time of trial. So if you had repaired the security system the day after the rape or the assault, none of that information about the repair goes before the jury at any time, unless the issue of ownership is an issue before the jury. But as long as the school admits to ownership of the building, and no subsequent repairs are admissible at the time of trial. Are they discoverable? That would depend on what judge you get. So that's why I say typically you'd have to let them on to see it.
Okay. Okay. So now you're at trial, which would appear to be a very nerve-wracking experience. All the discovery, I guess, is done. Everyone who needs to be deposed was deposed. Who typically, let's use the example of a security issue in a dorm where an intruder got in and sexually assaulted, let's say, a student who lives in the dorm. In a case like that, who would typically be required to appear on behalf of the university? Is it only the people who are deposed? And just tell us what your experience might be.
Okay. Certainly the people that were deposed would be witnesses that would be called at the time of trial. Typically, if any of the defendant's witnesses gave even a portion of their testimony that was favorable to the plaintiff, plaintiff's counsel will subpoena those witnesses, and typically those subpoenas would be served directly on the person, or in some states they can be served on the business official at the administrative offices for demanding their appearance in court on a certain day. Typically, the subpoena on the bottom will say, please contact your attorney, and they do that so that we don't have 15 witnesses showing up on one day and everybody's wasting their time. The attorneys can certainly try and schedule the time that we know is precious to you, so you're not sitting there wasting time in court. Definitely the people that have been deposed would come in, otherwise you get what's called a missing witness charge. And at that time, plaintiff's counsel or defense counsel can call any additional witnesses that they think might be helpful to their case. Once again, if plaintiff's counsel is calling them, they have to still be in the employment of the college at the time of the trial. Prior to coming to trial, they will meet extensively with the person handling the trial, the counsel. They'll either come to your campus and view the scene with the witness directly and then proceed to someone's office or a quiet spot to sit. They will, again, like I gave you the general rules of a deposition, they'll give you the general rules of a trial. Typically, when you have already been deposed, you can be fairly certain plaintiff's counsel in that case will only ask you questions that you've already been asked at the time of a deposition, because they don't want to be surprised with an answer that would be unfavorable to them at the time of trial. Your attorney will advise you, but typically you just come neatly or professionally dressed to the trial. We're not going to ask a maintenance worker typically to come in a suit. We just want them to come either in their uniform or in some type of neat clothing, just to give clear, concise answers, to make good eye contact, not to engage the other attorney if they do become argumentative, not to engage the judge if they do, and just to typically anticipate cross-examination questions from the other side, which are more argumentative questions. But what I always tell my witness is that a cross-examination question is different than a direct examination question. A direct examination question, the example being, how long have you been employed by X college? And a cross-examination question, isn't it a fact you've been employed by X college for 6 years? If you can get past the emotional part of being cross-examined, the questions are actually much easier to answer. They're typically yes, no answers, and you would go through all of that preparation with your counsel prior to trial. They can pretty much take a good guesstimate as to exactly what you're going to be asked on the stand. So there's not as many surprises as you would think.
Okay. The deposition, there's no judge in the room?
No judge in the room. There's a court reporter who has sworn or affirmed the witness to make truthful answers, and a transcript is taken of exact testimony. And this is, we're talking civil cases. In criminal cases, it might be different in jurisdiction to jurisdiction, but yes.
Now, in a trial, the judge is obviously there.
Judge is there, and typically, unless what we call a bench trial, meaning just in front of a judge, typically a jury of your peers is there, because if you've gotten to the stage of trial, that means there's an issue of fact for the jurors to decide. If there are no issues of fact, and there are simply issues of law, meaning a defense counsel can say to the court, there are no issues of fact. As a matter of fact, I'm going to ask the court to take the plaintiff's version of events, even if mine are different. Take the plaintiff's version of events. There's still no liability that can be found against the college because X, Y, and Z. Then the defense counsel will make a motion, in a sense, have a trial on paper to dismiss the action before it gets to the trial stage. If it's gotten to the trial stage, that means there's an issue of fact. The victim plaintiff is saying there was no security on the door and an assault occurred, and the school is saying the security was revamped 2 weeks before, it was state-of-the-art, brand new, someone else must have let this intruder onto the campus, et cetera. So there's a difference in fact.
So if let's say you have a CFO or a VP for finance that's being deposed, and it's getting kind of heated a little bit, can the witness look to their attorney and, in effect, like, help me?
Typically, you're going to be prepared, and it's usually best not to look at the attorney if you're being questioned by adverse counsel. But at that point, if you really see that your witness is being treated as a hostile witness and he's not, in a sense, hostile, meaning hostile equaling adverse, then typically your defense counsel will ask to approach the bench and ask the judge privately for the opposing counsel to take it down a notch, tone it down, that the witness is complying with the questions. There's no need to be as argumentative as adverse counsel is being. But typically when you're on a stand in front of the jurors, I can't pull you out of the room, as what you said happened to you during a deposition, et cetera. Right. So you have to go with the flow, and I just always say the nastier they get, the nicer you get, because you're in front of a jury of peers, and you just look like the more sane. And like we said, there's an issue of fact, so they're going to believe someone and not believe someone. And if the attorney is trying that hard to rattle you, sometimes they're doing that because they've got nothing else to grasp onto for their case, and the jurors oftentimes see right through that.
What affects jurors in terms of liking, not liking, believing, and not believing?
Demeanor of the witness on the stand is key. Oftentimes, they even say, don't confuse me with the facts of the case. We just want to see who we like and who's behaving and who's being kind and who we genuinely believe was supervising and caring for and being responsible for these plaintiffs in a school setting.
Okay. So if you're coming in as a CFO of a college, they would expect you to look, dress, have the demeanor of a CFO of a college.
Absolutely.
And if you're a buildings and grounds person who was responsible for cleaning up leaves that day, as you said, you come in a uniform, and they don't expect you, perhaps, to act in the same way as somebody might from central administration.
Exactly. And on the opening and closing arguments, counsel will often advise the jury, these are even if it's a CFO, it's not someone who is typically deposed. These are not professional witnesses. They're nervous on the stand just as everyone else is, and any kind of insecurities or rattling that you had on the stand can oftentimes be explained away in the closing arguments by your attorney.
Okay. So let's say there's a trial coming up. You're one of the witnesses for a college. You have a vacation booked, paid for, and you're ready to go.
Mm-hmm. Your attorney can do their best to rearrange that with the court, but typically if you're under subpoena, there are jurisdictional issues depending on what jurisdiction you're in, but typically the only way you get out of it is if you are 100 miles or more away type of thing, or if the judge finds out you received the subpoena and you had a way to rearrange your travel plans. It all depends on what jurisdiction you're in, and within that, what judge you have, et cetera. Oftentimes, if that really is the case, and the litigation trial is going to take longer than a few days, when I told you all witnesses go in the order of the caption, same is true at the time of trial. Each party will present their case in the order of the caption. But if you have a key witness that is out of state, oftentimes the judge will explain to the jury, because of scheduling issues, you're now going to hear from the third defendant before you have an opportunity to hear the second defendant rest their case. So they'll do the best they can. If you're gone for a long, extended period of time, usually it's not to the advantage of the defense counsel if one of their key witnesses are missing, but you just work with what you have.
Okay. And I think that kind of ends it for us. Just, I guess, a few points of, obviously, be honest. Not always easy, particularly if it's being honest maybe establishes some negligence against the college or university, but, you know, you're under oath, and follow defense counsel's advice, be prepared. Hopefully this webinar gave you some idea as to what to expect during each stage of the process for these particular type of cases. And, you know, there are people out there that are really available to you. I mean, your broker is, certainly anybody within your institution, depending on who you might be. Your defense counsel might be available. The insurance company people are certainly available. And then defense counsel who's appointed, they are your representative. So you could speak to your own counsel, you know, university counsel, and defense counsel as well. Anything else, Paula?
No, I would just add to that when you are being deposed, all the defense counsel wants is the truth at that stage. They never want the truth to come out at the time of trial, because that's when your insurance company determines whether or not to resolve the matter in a way prior to trial.
Okay.
So
if you know something at deposition, you
tell us.
You tell defense counsel, look, I don't know, this is going to work. Well, we were short 2 guys that night. We really didn't get a chance to clean that sidewalk more than once. We did it. It snowed another 8 inches. We never got there. Better you know that right away.
Absolutely.
Okay. Bruce?
All right. Thank you very much, Bob and Paula. It was a lot of information. We appreciate so much your willingness to spend some time with us and share your expertise and your experience. Thank you again to Wright Specialty Insurance for sponsoring today. Folks, you can see now why we've broken this series into 3 weeks. There's a lot of information here. So if you'd like a copy of the recording, you can see my email address and phone number there. Just simply let me know. You are automatically signed up for the next 2 pieces of this series, next week and the following. But if you'd like to sign up for any future ABAC focus webinars, you can see the address there, myabac.org. Thank you very much for joining us, and we will see you all next week. Have a good day.
Thank you now.
Thank you.